Well, good afternoon, everybody. It's Brian Horlick, condominium lawyer, senior partner at Horlick, Levitt, Lella, broadcasting our usual weekly AMA, Ask Me Anything, legal seminar for everybody. As you know, we started this way back in March when COVID-19 was the rage. We continued on a weekly basis giving legal advice, emotional advice, some humor, a little bit of music, and we were trying to keep everybody in touch during the pandemic because everybody was working remotely and independently. As we continued moving forward with our AMAs, the COVID pandemic seemed to be subsiding. There were less cases. More people were starting to feel better physically and emotionally. And then, unfortunately, COVID-19 had a resurgence. It was the resurgence that everybody expected, but nobody wanted to believe. And therefore, we are now back, having been in stage 1 in Toronto, having then gone to stage 2 where things opened up a little bit. Finally got to stage 3 where people saw the light at the end of the tunnel. We've now gone backwards to a modified stage 2, which is unfortunate, which is necessary, which is disappointing. And here we are in a place where I guess we didn't think we'd go back to, but we're there. So, moving ahead with our AMA, we're going to discuss what this all means. We're going to answer your questions from a legal perspective as best as we can. I can tell you now that Ontario Regulation 363/20 is the regulation that deals with the stages of reopening. Ottawa, Toronto, Peel, and now York are back to stage 2, a modified stage 2. The rest of Ontario still remains in stage 3 for now. Let's hope they continue. The rest of Ontario, for example, City of Hamilton, Niagara, Kingston, Lambton, Middlesex, London, Peterborough, Wellington, Windsor, all in stage 3. And unfortunately, as I said, Peel, Toronto, York, Ottawa, modified stage 2. Now, for all of you that are our loyal followers and others that are not and should be, we send out a weekly FAQ on COVID-19 updates. That goes out every Monday or Tuesday, depending upon what the government is up to. If the government is going to be coming out with some announcements on the weekend or on Monday, we will send out our FAQ on Tuesday. If there's nothing happening on the weekend, we'll try to send it out on Monday. I know that many of you board members, condominium management service providers, look forward to the FAQ to assist in advising your residents and your clients. So what does the modified stage 2 look like, and what is important to know? In a nutshell, indoor gyms and fitness centers are now closed. Indoor food and drink, service and restaurants closed. Restrictions on indoor gatherings has been moved down back to a maximum of 10 people in a social setting indoors and a maximum of 25 outdoors. So social settings inside, 10 people, no more than 10. Outside, no more than 25. Fines are starting at $10,000 for exceeding the gathering limits, and guests of events that are in excess of the indoor or outdoor gathering limits can face a ticket of $750. And if you've been reading the news, there have been some, we call them COVIDiots, who have had parties, big parties, and there were a number of fines that were handed out to the guests, as well as a fine to the host of such a party. Now, the Regulation 263/20 is the regulation that sets out what is open, what is closed in the modified stage 2. It is a total of 18 pages, and what I'm going to do is I'm going to give you the Coles Notes version of what's in the regulation so that you can have the up-to-date knowledge. So basically, there's a general compliance section, and that says that if you're a business or an organization, you need to operate in accordance with the applicable laws, including occupational health and safety. You need to follow the advice, recommendation, or instruction of public health officials regarding physical distancing, cleaning, and disinfecting. You need to comply with the advice and recommendations issued by the Chief Medical Officer on screening individuals, and you need to ensure that the mask policy or face covering policy for indoor areas is being complied with, other than the exceptions, and there's a number of exceptions, as we all know. If you're less than 2 years of age, or if you're a brat, just kidding. If you have a medical condition and you can't wear a mask, if you are unable to put on or take off the mask yourself, if you have to be accommodated under the Human Rights Code, there's a number of exceptions that will allow you not to wear the mask or face covering, and those in charge of the premises are not allowed to ask you to ask you to provide evidence of the exemption. Now, meeting or event spaces, when the social gatherings were initially reduced during stage 3. You only had a certain amount of people that could get together, but some members of the community thought, hey, if we can go to an event space where they allow more people, maybe we'll have our AGM there. And so some condo corporations actually did go to event centers or rooms of hotels that were sort of like convention type places, and they were able to move forward with their annual general meetings. Of course, that is now gone by the wayside because the social gatherings have now been reduced to a maximum of 10 persons inside. So not the place to be if you want to have an AGM. Most condo corporations now, if not all, are going with virtual AGMs with electronic voting. For those corporations where they feel that the community will be able to find that to be of assistance, there are some corporations where managers have advised that because of the demographics in that corporation, many of the owners or the majority of the owners are not computer literate or computer savvy, and so for those type of corporations, AGMs have gone forward with the use of paper proxies. So that's the ability, using the old paper proxies, to vote, to participate democratically. And some condo corporations have gone forward with having their meetings broadcast to the owners either by phone or on computer, with the voting by paper proxy and or electronic submission, electronic links to vote. So going forward in the, again, modified stage 2, for those jurisdictions that are in modified stage 2, the fitness facilities are no more. The gyms are no more. Washrooms, locker rooms, change rooms, etc. are no more unless they are necessary to be used for purposes that are allowed, such as the swimming pool. So you're allowed to use the pool. The pools can stay open. The gyms cannot. And when you're making sure that you do have locker rooms open and change rooms, they have to be cleaned frequently, maintain sanitary conditions. People cannot be closer than the minimum 2 meters, and all of the health directives need to be followed. So, moving forward here, we all know you, as an aside, you can't go to the restaurants and eat inside. You cannot do that. But you can do takeout, and that's fine. Now, for services, and this relates to condos, what we have here is the splash pools, splash pads and pools and wading pools are allowed. Indoor activities and services can be allowed other than the non-aquatic sports and recreational fitness activities. So if you have multi-purpose facilities, they can open, and they can open for the following purposes: indoor activities and services other than aquatic indoor sports, other than recreational fitness activities. You can have, as I said, pools and splash pads and wading pools. If you're doing short-term rentals, again, fitness centers or gyms must be closed. And for all corporations, steam rooms, saunas, whirlpools, or hot tubs must be closed. Now, as far as we spoke about conference centers and convention centers, they can be open, but they can only be opened using physical distance of at least 2 meters. And as well, maximum of 10 persons inside and 25 persons outside. So I think the convention business is not going to be going so well. Now, sports and fitness, we have the multi-purpose facilities. You cannot have exercise studios open, yoga studios open, or other facilities unless they comply. So basically, no indoor fitness, no exercise classes, they have to be closed. Any area containing weights or exercise machines has to be closed. And for the areas that can stay open, at least 2 meters distance between people, not exceeding 10 people. If you have an organized program or activity, those activities have to be taking place in separate rooms. And again, locker rooms, change rooms, showers, etc. have to be closed unless they are being used for the washroom purposes, or they are being used in conjunction with, let's say, the pool, which is going to be opened. If you have equipment that owners have to rent or use or take out, the equipment has to be cleaned up between each use. Now, moving ahead, what we have here is the Reopening of Ontario Act, which moved forward with the suspension. There was a number of provisions that were put in to assist with the fact that we had COVID, and there had to be provisions for people not getting together at the same time. And so there were emergency orders, there were provisions put in, for example, meetings of directors could be called electronically. It could be a meeting could be called by email, and it could be held by Zoom. It could be held virtually. It could be held by telephone. Now, as you know, under the Condominium Act, normally if you're going to have a meeting of directors, and if you want to have that meeting to be held virtually, then what happens is that every single board member has to agree. There has to be unanimous agreement to hold the board meeting virtually. With the pandemic and the amendments to the Condominium Act, this was suspended, whereby board members could hold a meeting virtually, electronically, or by telephone, and you did not have to have unanimous approval of the board members. Now, this provision, along with a number of other provisions, has been extended, and the provisions have been extended to May the 31st, 2021. So between now and May 31st, you can still call a meeting electronically for board members, and you can still have your board's meeting electronically without the necessity for unanimous approval. As well, for meetings of owners, as you know, if you wish to serve unit owners with the communications for your meetings, the unit owners have to sign a certain document that allows them to be served in that manner. Now, with the pandemic and the amendments to the Condominium Act, owners can be served electronically without signing an agreement. And again, they can do that up until the end of May 2021. In addition, if you're going to be counted for the quorum of a meeting, as long as you make an electronic link to the meeting, you will be counted into the quorum, and that is another provision that is going to be in place until May of 2021. Now, what's really important is up until May of 2021, you are able to have a virtual meeting. You are able to vote electronically without the necessity for a bylaw. After May 2021, the only way that you can have a virtual meeting or vote electronically is with a bylaw. So what we are doing, as I presume other condominium lawyers, is we are highly encouraging all condo corporations to pass a bylaw now, and in fact, if they're in the midst of having their AGM, to add that bylaw as an agenda item onto their AGM and have a bylaw passed now, which would allow the board the opportunity at its discretion to have a meeting virtually and to vote electronically. So this is very important because after May of 2021, condo corporations will not be able to do that without having a bylaw in place. And we don't know where this pandemic is taking us, and we don't know how long this pandemic is going to be with us, and condominium corporations must take care of their business and must move along with their business. And therefore, if the pandemic is still with us in May of 2021, corporations do not want to be found in the position whereby they cannot move forward with their meetings because they don't have a bylaw in place. So very, very important to do. Now, I'm noticing that we are not getting our questions. And I know last week Bradley Chaplik mentioned that there was a problem with the feature, with the YouTube feature where the questions were not coming in. And I'm wondering if we're having the same issue today because I don't see the questions coming in. I'm just going to take a moment to see if we can adjust that. So just give me a moment here. All right, I've now sent out an SOS to my computer geniuses, of which I am not one, and hopefully we can get that going. If we can't, and if you have questions and you're not able to get them through, then you can always email them in, and we can follow that up next week. So let's get to fan mail, shall we? Yes, let's do that. So as many people know, or should know, our office. Okay, we have now questions coming in. Thank you. Our office has put together a meeting program. And what happened was we noticed and we saw that many of our clients and others in the condominium industry were desperate to have their AGMs. They had to do them electronically because really there was no other way to do that. And there were only one or two service providers out there that offered virtual meetings and electronic voting. A lot of clients felt that the pricing was too high. A lot of clients felt that, it was difficult to get meetings when they wanted to, and it was a real industry issue. And we put our heads together and we said, okay, why don't we do something here to help the condo managers and the board members in the condominium industry? And we sourced out what I feel, and many feel, is the best state-of-the-art electronic voting software, not only in the condominium industry, but for corporations in general. And we sourced out a wonderful product. Our office, under the banner HLD Meetings, is chairing and hosting annual general meetings, owner meetings such as bylaw meetings, and other type of meetings for corporations. And everybody has really been very positive with the experience they've had. So I'm just going to read out 3 pieces of fan mail, because I must. That's why. So here's one from a smaller townhouse condominium corporation with a community of, let's say, more mature individuals, residents and owners, who really weren't enthusiastic about this whole computer electronic thing. And this is what they said. I just wanted to let you know that the board of directors and I, president of the board, were so impressed by how well you ran the AGM for our corporation last night. We particularly appreciated your patience with us during the rehearsal time. It was the first virtual AGM that any of us had attended, and we weren't quite sure what to expect. You ran the meeting so professionally and smoothly that it exceeded all of our expectations. Mr. Horlick was an excellent chairperson. He was so warm, as well as being professional and businesslike. The service offered by your firm was first rate and, in brackets, smiley face, reasonably priced. So there's some fan mail for you. And I have 2 more pieces. I don't want to bore you. The next one is, I had a very good experience with Horlick, Levitt, and Lella's meetings, especially with Bharat Kapoor. Bharat is one of our associate condominium lawyers. I have done 3 AGMs. This is from a condo manager. I have done 3 AGMs with Bharat, and he was very professional and always available. At the end of the AGM, all board members were happy with the way Bharat handled the AGM, a very good experience. And finally, from a regional manager, Brian, thank you so much for super chairing. I expected that we would go longer than 2 hours and 10 minutes, so it's all good. So those are just some of the fan mails that have come in, of the multitude that I won't bore you with, but I just want you to know that the meetings are going really well. And I want you to know that what I have found is that these virtual meetings, being a first-time goal for many condo corporations, many board members, and many managers, are a source of tremendous anxiety. And everybody's nervous before the AGM. The board members are nervous. The manager's nervous. Nobody knows what's going to happen. And we spend a lot of time with everybody, and we rehearse everybody. And everything, I will tell you, is going great. So for all of you that are nervous and apprehensive, whether you're a board member or a manager, I give you the Brian Horlick guarantee. You got nothing to worry about, and we'll take good care of you. Now, we have a bunch of questions that have come in since I told everybody that we had none. And since we have them, I'm now going to go through them. So Harlan Stavis, the resident, I guess, director and all-around great guy and an insightful man, says, the problem with no questions is you're too efficient and you answer the questions before we ask them. So Harlan, this sounds sort of like, when you're in life, when you get married, you don't even have to ask anything to your wife. She's already answering the questions before you open your mouth. And that's why sometimes we can never open our mouths. This is what goes on. Okay, Olivia. Hi, Brian. How are you? Great virtual AGM yesterday with your team. Thumbs up to Bharat and Paras. So that's very nice of you, Olivia. Olivia is managing a community of residents, a beautiful area up in Ballantree, surrounded by a golf course. And everybody, again, was really a little bit nervous in anticipation of the first AGM, but don't worry, everything went well, and thank you, Olivia. Hugo Sarin, I sit on the board for my condo building. The residents of my building had 5 exits available to them through the ground floor corridors. All right. On the ground floor, there are townhouses which have entrances to their residence in 3 of these corridors. The residents asked that these corridors be closed because they have vulnerable individuals living in them. The board at the time decided to obey the corridors. Okay. You see, I'm seeing what's happening here is when you have a long question, lots of other questions come in between. So going back with Hugo, I'm going down the list here. Fast forward to today, the board considered opening the corridors but was met with opposition from the residents of these corridors, and they are threatening litigation if we open them. My question is, do we open them? Do we open ourselves to liability if we open these corridors? So Hugo, I'm going to tell you this is a complicated question, and the answer lies in a review of your declaration and your rules, and perhaps some zoning issues with the city when the corporation was built. I cannot answer that question today, but I will tell you it's an issue of what's in your deck, what's in your bylaws, your rules, what were the expectations of the owners when they purchased. There's a lot. This is a very complicated question. It's a law school question. There definitely is an answer for that, and I just cannot tell you right now, but there's a lot of involved review for that. Okay. Next question. Catherine Barbolini. She always scares me because, she is a condominium manager, but quite frankly, I wouldn't say she should have been a lawyer. She should have been a law professor, because she's at that level with her acumen in law is regarding condominiums. So let's read Catherine's scary question. Brian, recommendation please. A resident who, upon receiving a rule enforcement letter, calls you a racist each time a letter is received. Catherine, no racism directly or indirectly has been found. After investigated by the board of directors, the administrator is becoming increasingly offended and frustrated with these allegations. So this is truly unfortunate. I will tell you that, we have human rights. We have, protections for people for discrimination. Unfortunately, and I don't know your case specifically, but unfortunately, there are people that see racism or sexism under every rock and in every nook and in every cranny. There are people that use the human rights code, the issue of racism, the issue of sexism, not as a shield, but as a sword. And there are people that will attack you wrongfully based on that type of thing. So, we had an AGM a year or two ago, and it was an issue where the person running for the board, I guess a director or a former director running again, was of the view that every time he was told that he couldn't do what he wanted to do, it was because of, his race or his color. And clearly that was not so. Clearly that was offensive to the recipients of those comments and to the community at large. And really and truly, it was dealt with as you need to deal with it in your building. And I'm going to suggest that, if somebody is not complying with the written declaration, the written rules, the issue is a matter of enforcement and not a matter of race. And so as long as you are consistently enforcing your rules and your use provisions in your declaration, doing that in an even-handed manner, I wouldn't, I wouldn't be offended with what the person is saying, because not only are they saying it to you, they're saying it to everybody. So I would just move on with your business. What you might want to do is escalate the issues away from your admin, who's not really being properly treated. Some might even say that she's the one who's being subjected to harassment, and she's the one that it needs to be protected. I might escalate that to legal so that it gets out of the hands of the condo. Next question. Carrie Wong, any suggestions for accommodations when running virtual meetings? Well, accommodations, I'm wondering what type of accommodations you have in mind. Are you saying accommodations for someone perhaps with a disability? Are you saying, how you want to run it? I can tell you that if somebody has a disability, they need to be accommodated. And if you have somebody, let us say there is someone who has a hearing issue in your condominium corporation, I definitely would accommodate them by perhaps having someone doing or carrying on the communication in sign language. And there's something there that can be done there. There are different ways to accommodate people with disabilities, and I would say yes, 100%. If you have owners who wish to participate or view the virtual AGM, absolutely take steps to accommodate those people. Next, Harlan Stavis, you're scaring me now before I even read your question. I can attest to the fact that our AGM went very smoothly. Bharat did a great job explaining everything during our rehearsal. Okay, so that's very nice of you, Harlan. Thank you. I just want to say again that not only people that are, the mature residents, but there are many people that haven't had any experience with virtual meetings, proxy voting, electronic links, and they are all uptight, nervous, anxious, and we go to great lengths to put everybody at ease and to make sure everything is working. But I will tell you one thing that we have found is when we do send out our registrations for the meeting, and once you click on as being registered for the meeting, you are then part of the quorum, so that's really great. So even if you don't show up at the meeting, but you register for the meeting, under the Condominium Act amendments, you are part of the quorum, which really helps save a lot of meetings because you need 25% quorum to move forward with your business. We have found that a number of people, although they are getting links or they're getting their voting links, their computers are set up in such a manner that it's going into their junk. And so what you need to do, all of the people listening, if you're having virtual meetings, and you don't see your links, you got to go and look into the junk mail because of your computer settings, and the stuff is there. So a lot of times in the virtual AGMs, when we open up the meetings, people say, I didn't get my voting link, because we send out our voting links, during the AGM after, the candidates are announced, and if they're, our speeches, they do their speeches and they're nominated, etc. We send out the voting links, and a number of people may type in on the chat or the Q&A, I didn't get my link. The reason they didn't get their link is because it's sitting there in their junk. And we go through that with everybody because we have a dashboard with our software that shows who got the voting links and to what email address and whether they actually opened the email or not. We have all of that written out. So, as an aside, we had somebody at a meeting last night, an irate owner, who demanded that because he did not receive his voting link, that the meeting be canceled. And we looked at our dashboard, and every person who was registered got their voting link. We were able to determine based on the software that this person also was sent the voting link, that the person actually clicked on it to open it, and then there was any issues would have been issues with his own computer. And of course, we didn't close up the meeting and cancel it, we moved it forward. So these are some of the things that are happening with the virtual meetings. But I would say that as long as you have a little rehearsal before the meeting, you should be fine. As long as your provider knows what he or she is doing, you have to have an experienced host, and you have to have a good chair, and everything will go accordingly, and you will be shocked how good the experience can be. So it's like a lot of things in life, before you do them, it's like, oh my God, I cannot do it. It's not possible. It's going to be terrible. and then you do it and you say, that wasn't so bad at all. In fact, I almost liked it. I think I'll do it next year again. All right, questions. We have Kerry Wong saying thank you. Barat, thank you, Olivia. Barat, thank you, Harland. Olivia, you are welcome. One more AGM to go. I'm looking forward to it. Well, see, that's exactly what I'm saying. Before Olivia had any of her AGMs, I bet she was a bit nervous, and now she knows it's a breeze. All right, I'm going to now wait for a few more questions, and I will discuss with you some of the items in our FAQ. As I said, these things are going out every week. I know a lot of people wait for them every week, and especially condo lawyers who will not admit it publicly, but they wait for our FAQ to come out so that they can then give proper, competent, reliable legal advice to their clients, who, by the way, will soon be our clients. So here we are, FAQ. We told you York, Toronto, Peel, and Ottawa are in a modified stage 2. We told you that. We've told you as far as exercise rooms are concerned, you need to close your amenity gyms. That's absolute. Any areas containing weights or exercise machines must be closed. Swimming pools can stay open. Steam rooms, sauna, and hot tubs must be closed. Outdoor amenities can stay open as long as the amenities have under 25 people and you are monitoring those areas and sanitizing those amenity areas. Real estate, open houses. Real estate open houses cannot have more than 10 people. The people that are at those open houses must maintain physical distancing. However, as we have said time and again, condominium corporations are able to make policies and rules that are more restrictive than those of the Ontario government. So a high-rise condo with many, many units is in a different situation than having a single-family dwelling for the purposes of an open house. We are strongly of the view that condo corporations can prohibit open houses if they so desire, and they would do that by a policy or a rule. Okay, and as I mentioned I guess it was 2 weeks ago, there was a recent court case, Condo Corp 1704 and Fraser, in which case the condo corporation had passed a number of policies dealing with renovations. One of the owners was very upset about the policy, began doing her renovations contrary to the policy. The condo corporation took the owner to court. The condo corporation was very successful. The judge was of the view that the policy was like a rule and it was properly enforceable and it was reasonable. Okay, so moving forward, condo meetings, which we said, you can hold your meetings electronically without the bylaw up until May 31st, 2021. In our FAQ, we have a whole chart of the new dates for your AGMs, and we suggest you take a good look at that. Does Horlick, Levitt, Lella, do HLD meetings have available dates in November and December and further? The answer is yes. If you need a date, just give us a call and we will try very hard to accommodate you. There is, as of September 26th, a requirement for employers to conduct daily screening regarding employees' health, and there's a questionnaire of the things that you need to ask the employees. We suggest in the condo milieu that property management, superintendents, security staff, and other contractors be screened for their health. That's very important for people that are coming into your building. And there's a standard form of questionnaire which can be downloaded from the net. So let me just tell you this. I mentioned this 2 weeks ago. I'm going to mention it again. David Lella is a partner in our law firm. David specializes in condominium law and insurance law. David's practice includes construction deficiency issues and flooding issues, chargebacks regarding damage claims and deductibles, and the interplay between the indemnity clauses and the insurance policies. So David is going to be here next week, October the 28th. It's a session that is not to be missed. Everybody in every condo, whether you are in a townhouse or a high-rise, and especially in a high-rise, will be subjected to flooding from the units upstairs or the units next to you. You cannot live in a condo without being subjected to a flood. And if you don't have a flood yet, the flood is coming. So please, if you want to know anything about insurance, if you want to know anything about responsibility for the water damage, you need to attend next week's session, October the 28th, with David Lella. I tell you, the issue of insurance and deductibles is a mystery to many managers, and it is a mystery to many board members, and it is also a mystery to a number of condominium lawyers, but it is not a mystery to David Lella. He is a top quality insurance and condo lawyer, and if there's one session that you want to go and see, if there's a session that you should not miss, it's David's session next week, October the 28th. So, unless there are any more questions, we have 12:45 now. We're going to wrap it up in a few minutes. On the Julia Laurier front, yes, so if you are a regular viewer of our AMA, Ask Me Anything live stream, you will know that Julia Laurier, a fabulous condominium lawyer that works in our office and who's been on maternity leave taking care of her little baby, will be coming back in about 10 days. And I'm waiting desperately for her to come back for her great acumen in condominium law and her wonderful smiling face and beautiful personality. She's a tremendous lawyer. I suggest if you want somebody who can really work efficiently and give great client advice and service, you need to check out Julia, and you only have to wait 10 more days. So we're going to finish off with one last question here from Condo 782 Property Manager. If your contract states 2 weeks per year for severance pay and you have worked for 10 years, does the 60-day period that the management company has been given by the board count in the 2 weeks? I'm going to suggest that you're mixing up apples and oranges. So the 60-day period in the management company is between the condo corporation and the management company. The 2 weeks per year for severance pay deals with employees. So depending upon if you are an employee of the condo corp or if you're an employee of the management company, you will have a different answer. Here, and it continues the question, even if the management company is being paid for their service. Again, most of the times, the issue of severance is going to be downloaded to the independent contractor. So that's why a condo might say, I don't want the condo manager to be an employee of the corporation, or I don't want the superintendent to be an employee of the corporation. I want an independent third-party contractor who will take care of providing the condo manager or the superintendent or the concierge, and all of the employment issues fall on the independent contractor, usually, unless we're dealing with the Bill 7 issue. So that is it for the moment. We're going to tell you again next week, October 28th. You need to tune in to hear David. If you have any questions, save them up. We're happy to answer them, and we're happy to be of service to all of the condominium managers and the board members and the residents. We do condo, we love condo, and we love the industry. We're happy to assist and do our part. So until we see you again, have a wonderful rest of the week. Have a great upcoming weekend, and let us all hope for being a safe and secure. Hopefully the COVID cases will go down. Hopefully we'll be in stage 3, but we need to be diligent, careful, patient, and listen to the health authorities. Wear your masks, wash your hands, and keep your social distance, and take care of each other. I'm bidding you a good day. This is Brian Horlick. Thank you so much.